Notice to defendants. You are being sued. If you do not respond within the time required by the Alberta Rules of Court, a judgment may be entered against you without further notice. Statement of facts. The parties and property. 1. The plaintiff, Daniel Leo LEClair, resided with and cared for his mother, Lorraine LEClair, at the Spirit Ridge condominium complex located at number 105-1320 Rutherford Road, SW, Edmonton, Alberta, for approximately 20 years prior to June 29, 2024. 2. At all material times, Lorraine LEClair was 83 years old and suffered from 2 degenerative hip conditions that made extended standing physically painful. 3. The defendant, Kingsway Towing Group, Inc. Kingsway is a commercial towing company operating in Edmonton, Alberta. 4. The defendant, Ken Bach, is the owner and manager of Kingsway. 5. The defendant, Stephen Raymond Jules Ouellette, was a tow operator employed by Kingsway. 6. The defendant, Aaron Church, was a tow operator employed by Kingsway. 7. Russell Zadomirski was a former resident of the Spirit Ridge condominium complex. On June 29, 2024, Zadomirski had no authority from the condominium board or property management to request towing enforcement. Statement of claim. LEClair v. Kingsway Towing, Ken Bach et al., page 1 of 6. Jurisdiction. 8. All events giving rise to the causes of action herein occurred at number 105-1320 Rutherford Road, SW, Edmonton, Alberta, within the Judicial Centre of Edmonton and the jurisdiction of the Court of King's Bench of Alberta. Events of June 29, 2024. First tow operator, Ouellette. 9. On the morning of June 29, 2024, the plaintiff logged both of his vehicles into the Spirit Ridge Visitor Registry, as was his routine practice. The plaintiff had never received a parking complaint during his approximately 20 years of residing at the property. 10. The condominium management office was closed for the Canada Day holiday weekend. Management had confirmed that no work order for towing was issued for June 29, 2024, and that no towing would be ordered while the office was closed. No management staff or board members were on duty. 11. An Edmonton Police Service officer attended the property and issued a parking ticket to one of the plaintiff's vehicles. 12. Shortly thereafter, defendant Ouellette arrived on the property in a Kingsway tow truck and positioned his vehicle behind the plaintiff's parked vehicle. Kingsway held no contract authorizing towing enforcement at Spirit Ridge. 13. A neighbor observed Ouellette's tow truck and alerted Lorraine LEClair. 14. Lorraine LEClair went outside to the parking lot to explain that a mistake had been made. She attempted to speak to Ouellette through his window. He ignored her and drove away. At this time, the plaintiff was not yet present on the property. 15. Over the following approximately 15 minutes, Ouellette circled the parking lot repeatedly in a threatening manner. Lorraine LEClair attempted 3 additional times to speak with Ouellette as he passed. Standing for this extended period caused her significant physical pain from her hip conditions. All of this threatening and intimidating conduct occurred before the plaintiff returned to the property. 16. Lorraine LEClair telephoned the plaintiff repeatedly, pleading with him to return. The plaintiff rushed back to the property. 17. Upon arrival, the plaintiff told Ouellette that his mother had 2 bad hips and needed to go inside to sit down. Ouellette exited his truck. A verbal exchange occurred. 18. As the plaintiff turned to walk his mother back toward her condominium, Ouellette lunged his head toward the plaintiff. 19. Ouellette then departed the property. Statement of claim. LEClair v. Kingsway Towing, Ken Bach et al., page 2 of 6. Events of June 29, 2024. Second tow operator, Church. 20. The plaintiff took his mother inside her condominium. He then drove his ticketed vehicle to a nearby hotel and parked it safely. His mother followed in her own vehicle. They then returned together to the Spirit Ridge parking area in his mother's vehicle. 21. Approximately 45 minutes after Ouellette departed, the plaintiff and his mother returned to the parking lot. Defendant Church was already present in a Kingsway tow truck, backed up to the plaintiff's truck. 22. The plaintiff's truck was legally parked, had been properly logged into the visitor registry that morning, was not ticketed, and was not the subject of any towing order or lawful enforcement action. 23. Church exited his truck and made boxing gestures in the air. Church directed profanity and aggressive language at the plaintiff, including telling the plaintiff to go to hell. 24. Church re-entered his truck, backed up approximately 20 yards, repositioned the vehicle to line up directly toward the plaintiff, and accelerated directly toward him. 25. The plaintiff moved to his right to avoid the path of the vehicle. The front bumper of the tow truck struck the plaintiff on his left upper thigh, hyperextending his left knee. 26. Church then reversed the truck sharply and swung toward the plaintiff a second time. In the course of this maneuver, Church lost control of the vehicle and collided with a stationary third-party vehicle parked in the lot, causing property damage. 27. The plaintiff called out to condominium residents to phone police. The plaintiff directed his mother to leave the parking lot in her vehicle. The plaintiff and his mother drove across the street to a neighbor's residence. 28. Edmonton Police Service officers arrived approximately 5 minutes after Church's arrival, and approximately 45 minutes after Ouellette had departed. The officers proceeded to the plaintiff's location at the neighbor's residence. The plaintiff was detained and arrested. Injuries, 29. As a result of the strike by Church's tow truck, the plaintiff suffered physical trauma to his left upper thigh and hyperextension of his left knee, aggravating a pre-existing knee condition. Statement of claim. LEClair v. Kingsway Towing, Ken Bach, et al., page 3 of 6. Causes of action: assault and battery. Defendant Church. 30. Defendant Church intentionally accelerated a commercial tow truck directly toward the plaintiff while the plaintiff was on foot, striking him with the vehicle's front bumper on the left upper thigh and hyperextending his left knee. 31. Defendant Church then executed an aggressive reverse maneuver with the wheels angled toward the plaintiff, creating a reasonable apprehension of a second, imminent harmful strike. Trespass to premises. Defendants Kingsway, Bach, Ouellette, Church. 32. Defendants Kingsway, Bach, Ouellette, and Church entered private residential property at No. 105-1320 Rutherford Road, SW, Edmonton, Alberta, without contractual, municipal, or condominium board authority, and without verifying their authority to enter. Trespass to chattels and conversion. Defendants Kingsway, Bach, Ouellette, Church. 3-3. Defendants Kingsway, Bach, Ouellette, and Church interfered with the plaintiff's vehicles by backing commercial tow trucks up to them and positioning to remove them without contractual or legal authority. Negligence. Defendant Church. 34. Defendant Church owed the plaintiff a duty of care as an operator of a motor vehicle in a parking lot to avoid foreseeable harm to pedestrians. 35. Defendant Church breached that duty by A. Accelerating directly toward the plaintiff while the plaintiff was on foot, B. Failing to maintain a proper lookout, and C. Reversing without reasonable care, causing a collision with a stationary vehicle. 36. As a direct result of the breach, the plaintiff was struck on the left thigh, suffering knee hyperextension and related injuries. Statement of claim. LEClair v. Kingsway Towing, Ken Bach, et al., page 4 of 6. Intentional infliction of mental suffering. Defendants Ouellette and Church. 37. Defendant Ouellette circled a residential parking area repeatedly in the presence of an 83-year-old senior with mobility impairments, causing distress to both the plaintiff and his mother. 38. Defendant Church escalated the situation by accelerating a tow truck directly at the plaintiff, causing severe distress. Vicarious liability and personal liability of Ken Bach. 39. Defendant Kingsway is vicariously liable for the tortious acts of its employees, defendants Ouellette and Church, committed within the scope of their employment. 40. Defendant Ken Bach, as owner and manager of Kingsway, directed, authorized, or ratified the conduct of defendants Ouellette and Church. In the alternative, Bach is jointly liable as the directing mind of the corporation. Remedies sought. 41. The plaintiff claims against the defendants, jointly and severally: A. General damages for physical injury, permanent disability, emotional distress, humiliation, and loss of enjoyment of life in the amount of $250,000. B. Special damages for medical expenses to be proven at trial, estimated at $50,000. C. Aggravated and punitive damages for high-handed, oppressive, and malicious conduct in the amount of $100,000. D. Costs of this action. E. Pre-judgment and post-judgment interest pursuant to the Judgment Interest Act, RSA 2000, CJ1, and F. Such further and other relief as this honorable court deems just. Dated at Edmonton, Alberta, this 28th day of May 2026. /day/Daniel Leo LEClair. Daniel Leo LEClair. Plaintiff. Self-represented litigant. Administrative preparation assistance only. /S/Sarah D. Williamson. Sarah D. Williamson. Document preparation / records organization assistance. Statement of claim. LEClair v. Kingsway Towing, Ken Bach, et al., page 5 of 6. What to do if you are being sued. 42. You have a limited time to respond. You must file a statement of defense or a demand for notice with the Court of King's Bench of Alberta within 20 days of being served with this statement of claim if you are served in Alberta. If you are served outside Alberta but within Canada, you have 1 month. If you are served outside Canada, you have 2 months. 43. How to file. You can file your statement of defense in person at the Edmonton Courthouse, 1A Sir Winston Churchill Square, or electronically through the court's online filing service. You must also serve a copy on the plaintiff at the address for service listed on page 1 of this document. 44. Legal advice. You are strongly encouraged to seek legal advice immediately. You may contact the Lawyer Referral Service through the Law Society of Alberta or Legal Aid Alberta to discuss your options. 45. Consequences of not responding. If you fail to file a statement of defense within the required time, the plaintiff may apply to the court for a default judgment against you. This means a judgment may be entered for the full amount claimed without further notice to you, and enforcement proceedings may commence immediately. Statement of claim. LEClair v. Kingsway Towing, Ken Bach, et al., page 6 of 6. Checkmark final, 12 pt font, page 6 of 6. Clarified first operator address.